The Supreme Court said that racial bias in death penalty cases does not matter. It said that racism is constitutional and cannot be challenged. The Supreme Court said this in a 1987 case called McCleskey versus Kemp. Do me a favor and keep watching this video to the end to learn how the Supreme Court said that racism was constitutionally acceptable and how it impacts the entire justice system and how black people are treated in this country. The case involved a black man named Warren McCleskey. He was born into poverty and family dysfunction. In 1978, he committed a horrific crime and took the life of a white police officer during an armed robbery of a furniture store in Fulton County, Georgia. He was sentenced to death. His lawyers appealed his death sentence all the way to the U.S. Supreme Court. They argued that Georgia's death penalty system had racial bias in it and targeted black people with death sentences. To prove this, they presented a study of more than 2,000 capital cases in Georgia. It was known as the Baldus Study, after its author, Professor David Baldus. The evidence showed that people convicted in capital cases where the victim was white were 11 times more likely to get the death penalty than if the victim were black.